The topics and opinions expressed in the following show are solely those of the hosts and their guests and not those of W4CY Radio, its employees, or affiliates. We make no recommendations or endorsements for radio show programs, services, or products mentioned on air or on our web. No liability, explicit or implied, shall be extended to W4CY Radio or its employees or affiliates. Any questions or comments should be directed to those show hosts. Thank you for choosing W4CY Radio.
Welcome to the Ask the Expert show on W4CY Radio and Talk4 TV, where we bring you educational information from top local experts in the fields of legal, health, financial, and home improvement. Now sit back and listen to experts in family law, association law, hearing loss, business brokers, home care, along with many other topics. Now here are your hosts, Steve-O and Sophia.
Good afternoon, South Florida. Welcome to another Ask the Expert show. We are in our 10th year, and I was looking at all of our shows the other night around the country. We have 64 shows in 10 cities now, and that's a lot. And the only reason I bring that up, our next show, our show today, is our number one show, and it's been number one for about 6 years. It's based on the listenership, viewership, and we are so lucky to have them. And it's fun. We start off, they had an office in Pompano. They had one in West Palm Beach. And here, 8 years later, they're also now in Orlando. They're in Tampa. They own Florida. We're going to be talking about community association law today. Yeah, those of you who are in an HOA or condo, you have a problem, you have a question. We have senior partner Robert K with us, K. Bender Rimbaum. And here's how you get involved with the show, because we have so many people who call in, write in. You can text us at 954-336 3767. Most people we have a chat line, a board right next to the monitor, or you can call in at 561-623-9429. Let's welcome senior partner Robert K. Hi, buddy.
Hey, Steve. Hello, everybody.
Good to see
Happy
you.
August.
God, this year has gone by so fast. It seemed like I was just saying first Thursday of the month, last month, and here we are 4 weeks later, we're back again.
Happy to be here.
Well, listen, it's pretty obvious to give an hour of your time each month for the last 8 years. So I hate to do this to you, but I don't that we get so many letters in about your show, people who've just found it for the first time. Tell people about K. Bender Rimbaum.
Well, K. Bender Rimbaum has been providing services to community associations continuously since 1992. Started off in Fort Lauderdale and moved over to Pompano Beach sometime later, and then expanded to Palm Beach Gardens, and then Tampa and Orlando. And we are generally providing basic association services, complex association services, whatever a general need of an association is for legal services are things that we do. We do collection of assessments, interpretation of documents, interpretations of statutes, advising boards as to rights and obligations, enforcing documents, dealing with contractors, assisting in contract negotiation, loan documentation, doing construction defect litigation, anything and everything that involves community associations, legal needs. That's what K. Bender Rimbaum does.
Robert, we're starting to get a lot of letters from people who are interested in becoming a board member. And we just got one the other day from Tampa. And most people want to know how much time's involved in being a board member.
Well, that's going to depend on the community. Sometimes there's a big commitment of time. Sometimes it's a commitment of just attending the meetings when they occur and making the decisions as necessary. So it's really hard to say, because obviously each community has its own needs and obligations. It's a good idea, if anyone's interested, to attend board meetings and see how the association operates, make appointments to view the association's records. You can see how they're kept and what's going on in that situation. And just get generally involved with the association. Some people join a committee, if there are committees within the community, and get their feet wet that way before moving on to serving on the board. It can be rewarding, it can be frustrating, it can be a lot of things. It really depends on the community.
Let's go to our board. Let's start taking questions. Please clarify the new law expanding what is allowed to be stored behind homes.
Well, Chapter 720, the homeowner association statute was amended this year, effective in July, that prohibits associations from limiting the ability of owners to put certain items within their backyards that are not seen from the front. It's a little unclear as to the extent of how that goes, or whether it's even going to be enforceable against communities with existing covenants that do not have the particular language in their documents that incorporate new statutory changes, which is called Kaufman language, and is a generally complex legal issue. But sometimes statutes apply to everywhere in the community, sometimes only to certain parts of the, it depends on the statutory change. It's something that I'm sure we'll get involved with at some point more as we discuss things. But as it stands right now, the recent statutory change does allow owners to keep things in their backyard which otherwise had been prohibited under their documents. It's an open question at this point if that's an even enforceable law as it currently stands. I don't want to get too deep into the weeds.
You just brought up Kaufman language. We had Eileen in Delray Beach actually wants to know, what is Kaufman language?
Well, Kaufman was a case and had the decision of that case named after him. Basically, it's an issue of whether substantive statutory changes are effective within the various communities, depending on specific language that are contained within the governing documents. Under Florida Constitution, as well as United States Constitution, there's a provision that says that the state cannot adopt a law that will infringe upon an existing contractual relationship. The Declaration of Condominium, Declaration of Covenants is such a contractual relationship between the individual homeowner, unit owner, and the association. So for the legislature to adopt a statute that affects everyone all the time, it can be a complex issue, because statutes are considered either procedural or substantive. Procedural, an example of a procedural statute would be how elections are handled within a community. In 1992, the Condominium Act was substantially amended to change the election process from what used to be considered a standard corporate election procedure, where you'd send out a notice, people would send in proxies, vote how they wanted to what they've been using ever since 1992, and that is the absentee ballot format, with people submitting themselves with an intent to serve by a certain date, and then they send out an absentee ballot, and the voting goes through the inner envelope into the outer envelope, and signing the outer envelope to keep track of who's signing, keep a secret ballot, separating everything. The whole procedure was adopted in 1992 and considered procedural as opposed to substantive. Substantive would be something that's a little more complex relative to the rights of the owners. And on the last question about what you're not allowed to put on your property would be more of a substantive legal right and a vested interest under the documents through the statute to change it. And for it to be effective without amending your documents, there would be a provision that incorporates existing statutes as they are now and as they may be amended from time to time. The key language is as amended from time to time. So you'd have to look in your documents to see if there's a reference to either the Condominium Act or the Homeowners Association Act as amended from time to time. Sometimes it may refer to specific provisions. Sometimes it may refer to the entire document. So it can be a legal treatise on the subject, and I'm just scratching the surface with what I've described today.
Well, we're going to go to author in Delray Beach. He said, we are finishing up our 40-year electrical. I had an inspection by the condo electrician. They sent me a letter from the association what had to be done. I had an electrician come out and fix this. Just received a letter that I have to do another inspection. Shouldn't the association pay for that since I paid for the inspection with the electrician in the beginning?
You know, that's a little bit complicated set of circumstances that might go a little beyond what we can answer today, because there are facts and circumstances going on in that particular building that aren't indicated in the question. It's possible that, yes, you do have to pay for the subsequent inspection because you had issues that were found in the first inspection that created the problem in the first place. So it would not be unreasonable to require you to pay for the inspection after you've allegedly done the remedial measures to make sure that it is sufficient for the purpose that was required. So, you know, from the question, it's hard to say 100%, right, but it sounds like there are facts that could lead to that conclusion.
Robert, just curious, because things seem like they're changing all the time in the community association field. What kind of questions are you getting from board members now?
I wouldn't say there's any one particular question that's more prevalent than any others. Certainly there's concern over the changes to the requirements for condominium buildings on their structural inspections and what's going on with all of that. But there are always many other issues that are going on throughout the communities that are probably more frequently asked. The issue with the structural things was hot for a little while when it first comes up, but now everybody's kind of got a handle on what they've got to do. So, you know, those aren't as prevalent as they initially were.
We received a phone call a couple weeks ago, and we have talked about this many a times. Homeowners had to bring an architect out with the new laws that are going into effect, and they're telling him 6 to 9 months before they can get anybody out to him. You're getting anybody who's
certainly problematic because there's only so many people that do the type of work that's qualified.
Exactly.
There's only a limited amount of time to get it done. So it's going to be interesting to see if there's going to be extensions granted as things get closer to the deadlines. Obviously, only the legislature can do that. One thing that's changed recently in Broward County is that the county commissioners adopted an ordinance that provided that if there's the certification done was 30-year, the mention of it now 25-year certification, that would satisfy the requirements of the state SIRS and inspection in that regard. So Broward County has some relief given by ordinance, which is authorized by the statute for a local enforcement agency to adopt such a provision. Whether or not that's going to work out as intended is also an open question, because some of the things that were being inspected under the SIRS doesn't necessarily fall within the inspection of the 25, 30, or 40-year inspection.
Let's go to Mike in Boynton. He says, I am losing one member of a 5-member board. One board member suggested that only 3 members vote and the 4th member is used as a tiebreaker. I think this is wrong. Who is right?
Well, the writer is correct. It is wrong. All board members are supposed to consider and vote on all issues that come before the board. There is no tiebreaker, as it were. Each board member gets 1 vote, and it's not like Congress where or the Senate where the vice president breaks a tie. This is a different type of organization, and if it's a tie, then the motion fails. When you have a 5-member board, your quorum is 3, so you have to have at least 3 people participate. If somebody resigns and there's an open seat, that doesn't change anything. If 2 people resign, that doesn't change anything because you still have 5 seats, so your quorum remains 3. So everybody votes, everybody has 1 vote on the board, and however the issue turns out is what the board's going to do. So it's a good idea to have an odd number so that ties are unlikely, but you can't do it the way where 1 person is just a tiebreaker.
Robert, we had a lot of people wanting to know when your next certification class is. So why don't we just go into your schedule for August?
Okay. Starting next Tuesday, we have Navigating the Federal Fair Housing Act on Assistant Animals or Pets. A Zoom presentation from 11:30 to 12:45. Emily Gannon from Pompano will be presenting. There's 1 CEU available for CAMS. And then on August the 15th, Tuesday, the 2023 legislative session update, live via Zoom from 2 to 3:30. 2023 legislative update is for changes in the law in 2022. Alan Schwartzide of our Orlando office will be presenting, and it's hosted by Empire Management Group. On August 16th, Wednesday, from 11 a.m. to 2:30 p.m., we're going to have a combined HOA and Condominium Association board member certification. Alan Schwartzide will be teaching that as well. That's hosted by Century Management. That's live via Zoom. There's 3 CEUs available for that particular presentation. On August 23rd, live at the CAI Southeast Florida Expo at the Signature Grand at 10:15 to 11:15 a.m., there is a course that's called Source of Income Discrimination, which is involved in the reviewing of proposed purchaser applications. The instructor hasn't been identified yet, but there is 1 CEU for that course, and the event goes from 9:30 to 4 p.m. at the Signature Grand in Davie. On Thursday, August 24th, from 12 p.m. to 1:10 p.m., conflicts of interest, what you need to know. hosted by GRS Management. The instructor, Allison Hertz from our Palm Beach Gardens office. There is one CEU for CAMS as well. And the last item, August 29th, is the Condominium Association Board Member Certification from 12 noon to 2:30 p.m. live at the Orlando office, as well as via Zoom, with Alan Schwartzide instructing. And there's 2 CEUs available for CAMS to participate in that. So that's what we've got upcoming for August, and you kind of see that scrolling on your screen. If you're interested in any of those, go to kbrlegal.com, go to the events calendar on the first page, and then choose the item you're interested in and register to get the Zoom information so you can participate.
Well, we're going to rest our throats for a few minutes. We're going to go to break. When we come back, we have more with Robert K. Bender Rimbaum. We'll be right back.
K. Bender Rimbaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida. On kbrlegal.com, you can learn more about their offices in Pompano Beach, Palm Beach Gardens, Orlando, Tampa, as well as throughout Miami-Dade by appointment. Several K. Bender Rimbaum attorneys are board-certified specialists in condominium and plan development law and assist clients with all matters of community association legal issues while keeping them up to date on new developments that affect their associations. K. Bender Rimbaum is also a well-known provider of free legal education for managers and board members. Contact K. Bender Rimbaum today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or write to them at info@kbrlegal.com.
And we are back with the Ask the Expert show on W4CY Radio and Talk4 TV with your hosts, Steve-O, Sophia, and their expert guests.
And we are back. We've got so many questions here. If you have a question, you can see if you're watching today, we have a monitor and we have a chat line. You can ask a question. We've got literally 25 or 30 questions over the month from listeners and viewers who will be reading their questions. If you want to call here, you can call here. We've had some problems with our phone lines, but I think we've got them fixed now. The number, let me give you the number here, is 561. Wouldn't you know I would forget this? 561. Listen, I gave out the producer's number one time, and I thought I was going to freak out. It's 561-623-9429. Let me give it to you one more time. 561-623-9429. We're here with Robert K. He's the senior partner at K. Bender Rimbaum. We are asking your questions right now. Here's Cliff from Coconut Creek. If the board votes on changes to the rules and regulations in our condominium, are they required by law to post that specific meeting 14 days in advance? Or is it the usual 48 hours notice?
Well, that's an actually trick question, as it were, because there's both requirements depending on what the rules are going to be addressing. If the rule that's being adopted or changed involves the use of the unit, or in a homeowner association, the use of the lot, then it's required a 14-day notice. If the rule is just about using common areas, common elements, clubhouse, things of that nature, then a 48-hour notice is all that's required.
Okay. Let's go to Ray in Coral Springs. What happens if we are unable to get our milestone inspection completed? We have called, and this is one of the people I spoke to. We have called numerous companies, and they are unable to schedule another inspection. We knew this was going to happen.
We did, but the only advice I can offer at this point is keep trying. Keep looking for alternative providers. And as I say, when we get closer to the ultimate deadline, it's important, even if you can't schedule it before the deadline, if you get it scheduled at some point after the deadline and you show that you've got it scheduled and you're working toward getting it done, I don't see any real negative ramifications about that. But again, we have to wait and see how that's going to play out with the legislature next time.
I think it's going to get kind of crazy. Let's go to our chat board. For an HOA, I know owners that are not, I guess, shareholders. Here we go. Action against an existing board. Is it arbitration, mediation, or straight to court?
Okay, there is provisions in the statute for derivative actions under Chapter 617. It used to be just in 607 for the normal for-profit corporation with shareholders. That was expanded into 617 for membership situations. I don't believe that's going to go to arbitration, but it would go to the circuit court. Mediation is something that is ordered by the court or by the arbitrator, so that could apply to either setting. But it doesn't fall within the jurisdiction of the arbitration section of the Division of Condominium for condominiums if it's the derivative suit. So it would be in the court.
I want to even talk to you about this because you and I usually talk before the show. And I mean, we're in hurricane season now. Is there anything you want to tell people they should do because we've got a lot of New Yorkers down here now who've moved down here and who've never experienced a hurricane before, though New York does get hurricanes. Is there anything you want to tell people to get prepared? Because we're in the season now.
Well, hurricane preparedness is less a legal issue than it is a management issue. And while there are legal concerns relative to it, the best advice that I tend to think available is make sure that you can document the conditions of your property prior to any kind of a storm. It's best to do that in video, keeping lists of everything in a safe, secure place that would likely survive any kind of a hurricane event is certainly recommended. Beyond that,
go ahead.
I tend to refer the question more to the physical property management personnel for securing your property, and make sure you're aware of evacuation routes if you're in an area that does evacuate, and have a plan. Having a plan in place of what you're going to do when the hurricane strikes is also very important.
Let's go to Karen in Hollywood. If an HOA has a 5-category reserve, as noted in its document, what vote is required to move money between funds to make repairs? I want to know, is it a vote of the board or membership as per our documents?
Well, it would seem to me if the documents have specific reserves set up in them and a procedure for waiving them, then you would follow the procedure within the documents, unless they are less restrictive than what the statute provides, which is a majority vote of everyone to use reserves for purposes other than that for which they are being held. HOAs are a little more tricky because not every community qualifies for the statutorily protected reserves. That provision came into the statute only sometime around 2009. Prior to that, there was no requirement of reserves for HOAs, and there was no statutorily protected reserves. And whatever the documents provided was the way it was done, and most documents didn't say anything. So in order to qualify for statutory reserves, the most recent version of the statute provides that has to be voted into place by the owners. And now, since for communities created since 2009, it's a different standard because the statute was in place when they were created. So they're likely going to have that in their documents. But sometimes you think you have statutorily protected reserves when you don't, and then the board can do it as they want. You need to go over that specific provisions of your documents with the association's attorney to make sure that you're meeting the requirements of the statute, whichever way you go.
Becky in Coral Springs, I asked a question to the management company about seeing a contract with a vendor or their bid. After 10 days, what do I do when they continue to ignore me?
Well, the question doesn't indicate if the request was in writing or not. It needs to be in writing to start the statutory clock ticking, and it has to be presented in a form that's in accordance with the procedures of the community. So if the board has adopted rules that require the record inspection to be delivered by certified mail, then you need to deliver it by certified mail. Otherwise, it just has to be in some written form delivered to the association, and then there's 10 business days. If the association continues to ignore, in an HOA setting, the only remedy available to an owner is to file a lawsuit. You file a lawsuit for injunction to compel the association to provide access to the records, and for statutory damages, which is limited to $500. So it's not going to be, or actual damages, but it is really likely going to only be the $500 that the statute provides. So you would need to get with an independent attorney, and the attorney would need to get in touch with the association to see if maybe they'll take it a little more seriously.
Hey, here's Art Garfunkel's brother, Pablo. He wants to know, do rules and regulations of a 718 condo have to be logged with, I guess, the county, or is it enough to simply document these updates as adopted from time to time by management company along meetings? See, I got little writing here. You're getting the big stuff, so you answer it.
Okay. Pablo's asking if the board adopts new rules, do they have to record the rules in the county, just like the declaration is recorded if there's an amendment to that? So the law does not require the rules to be recorded, but if they're recorded at any point, then changes should continue to be recorded. Otherwise, there would be some confusion out there as to what applies. Generally speaking, in order for a rule to be effective, notice has to be given to the membership of the change. And one method of membership is, or of notification, is mailing it to everybody. Another is recording it in the public records, because that's constructive notice to the world. And it's a good idea to record them, because then there's a place that everybody can find them, and somebody can't say that they didn't know about them because they are in the public record. And again, it's very important, if they've ever been recorded, that any changes that are made to them also be recorded. But if they're not recorded and a change is made, notice to the owners still have to be given specifically by mail.
Okay, let's go to Jenny. Let's go there one. We are a 2-story condo complex. We got that Broward County inspection note about regulations and size. Do we also need to do a reserve study too?
Okay, the 2-story condominium doesn't fall into the structural integrity review, but it's still required to meet the 30-year certification requirement by the county. So that's probably the notice that they received. Reserve study is a good idea to do. It's recommended, so that you know what items need to be reserved for, and you have a accurate estimate of the useful life and how much it's going to cost to replace them. It's not a mandatory requirement, but it's a sound business decision to periodically do that. And once you do a reserve study, it's good for a little while, but it's not good forever. So every few years, it should be repeated.
Let's go to Barry and Aventura. Finally got somebody from Aventura. Board of Directors refuses to have meeting in presence as stated in our condo laws. Is that legal? They refuse, and they do all their meeting through Zoom only. And we're finding out, Robert, that I guess our little bit older demographics aren't very high on Zoom and don't want to do Zoom. So I'm sure that's the reason this is coming up.
Well, unfortunately for the writer, a Zoom meeting is one that qualifies as in the presence of. Owners have the ability to participate on the Zoom method, or there's an option to just be there by telephone, which also satisfies the requirements of present and being able to participate. They need to be able to hear everything that's going on from all parties, and they need to be able to be heard. You know, those are the basic requirements under the law. And it sounds like this particular association has not been in violation in doing that.
Okay. If you would, we've had a couple people write us. They missed the first half of the show. You mind going over the schedule again? Because they're on radio, not TV.
Sure. On Tuesday, August the 8th, 11:30 to 12:45, we're doing Navigating the Federal Fair Housing Act, Assistance Animal or Pet. Emily Gannon from Pompano Beach will be presenting. One CEU is available for CAMs. On Tuesday, August 15th, from 2 to 3:30 p.m. on Zoom, 2023 legislative session update. Instructor Alan Schwartzide. There is no CEU on this. It's hosted by Empire Management Group. On Wednesday, August 16th at 11 to 2:30 via Zoom, a joint HOA and Condominium Association Board Member Certification course. Alan Schwartzide will be presenting from our Orlando office, and there are 3 CEUs available for CAMs for this particular one, hosted by Century Management. On August 23rd, 10:15 to 11:15, live at the CAI Southeast Florida Expo at the Signature Grand in Davie. There will be a course called Source of Income Discrimination. That will be presented live. We don't have an instructor identified yet, but that's at the CAI Southeast Florida Expo on August the 23rd. That event runs from 9:30 to 4. On Thursday, August 24th, from 12 to 1:10 p.m., a Zoom Conflicts of Interest, What You Need to Know, hosted by GRS Management, Allison Hertz from Palm Beach office. will be instructing one CEU available. And then lastly, Tuesday, August 29th from 12 noon to 2:30 p.m. live at our Orlando office and via Zoom, Condo Association board member certification. At the office, space is limited, so if you're interested in attending in person, you'll want to register as soon as possible. Otherwise, go to kbrlegal.com on the website, click on the calendar, choose the event you want, and get your information for participation there.
Robert, how long is the board certification?
The board certification will last for 5 consecutive years of service, but if there's any break in the service, then you got to do it again.
Okay. Let's go to Greg in Hollandale. Great show again. How do I go back and listen to a past show? And that's really easy because you can go to your website, KB.
That's right. KBRlegal.com.
Yeah, you can go watch past shows. You can also go to iHeart and just put in Ask the Experts South Florida, and it'll say HOA Condo. You can go back and listen to past shows that way. And you can also go to YouTube. Same thing. You just put in Ask the Experts South Florida Community Association Law. So there's a lot of ways you can go back and listen to it, and tell your board, have like a lunch or something, and listen to the show again, because the shows are so educational, and you can really get a lot of great information. So we love when we hear you do that. We love it. You can want to go back and watch past shows. We're going to go to, let's go to Layla. Layla's in Palm Harbor. Our HOA is refusing to hold meetings to approve bids and expenditures like air conditioning changes. They're doing it all by email. With the property management being complacent in their actions, how should we pursue this?
And is this an HOA or a condo?
HOA.
HOA. All right. So this is not something that the division would be any help for. It is a requirement that the board take formal action on approving contractual issues, and they can do it at a meeting and should do it at a meeting. And they can also, if they're unanimous, they can do it by a written resolution, in which case they would not have to hold a meeting. But they're not allowed to take action by email alone. It's possible, if the management company is complacent as described, that a complaint against the manager with the Department of Business and Professional Regulation might help to resolve that, although the board makes the decisions and management really is not in a position to tell them what to do or give them legal advice. So such a complaint might not go beyond getting their attention to do things correctly. Unfortunately, the only other option available would be to hire an independent attorney, and if they fail to respond to written requirements of that attorney, then a lawsuit would have to be brought to compel them to operate correctly. If that's done, it's possible to recover attorney's fees if the owner prevails, but it's also a possibility of losing attorney's fees to the association if the association prevails. So it's important to make sure that any attorney you consult with is versed in the area of the law sufficiently to provide the assistance that's needed.
Okay, let's go to Larry in Pompano. Please explain the staggered term rule. HOA 300 units, new board elected 7/20/23, 2 resigned, 2 replacements installed. Attorney says 2 must step down by the next morning due to the staggered term. I've never heard that staggered term.
Well, the staggered term rule, as he's called it, is that sometimes documents will provide for not all board members to be up every year for re-election. So you'll have a 2 or a 3 year term. You have a 2-year term, then half or one over half. Let's say you have 5 board members, 3 are up 1 year, 2 are up the next. That way you get continuity on the board, and you're not getting new people every time you have an election. So that's going to be document specific. If a board member resigns, the documents also will tend to outline whether the replacement board member will serve until the next annual election or for the unexpired term of the person they're replacing. It's possible that the people who resigned were up for election next year, so that's why their seat is vacant occupied only until the next election, and not for. So the documents have to be reviewed, and specifically you have to know which director serves in which term.
Well, that brings us to the end of another great Ask the Expert show. We do the show, the South Florida show is the first Thursday of every month at 5 o'clock with attorney Robert Kay. We also do a Orlando show on Wednesdays, and we do a Tampa show on Thursdays. Let's give everybody the phone number, Robert, in case they'd like to set up a meeting with you.
You can reach us at 800-974-0680. Can also write to us at info@kbrlegal.com, or go to the website kbrlegal.com and click on the contact information box on the opening page and fill it out, and that will get to somebody who will get back to you to set up something.
I have to add this, Robert, because I take a lot of the phone calls during the month, and I hear the complaints, and some of them who already have a law firm on, I guess, retained, tell us that a lot of times it's hard to reach them. Customer service is really important to you.
It has always been since day one. We always require everything to be responded to timely. Responses the same day as they're received, if not with the answer, at least an acknowledgement that we have it, and we'll have something back to them shortly. We also require that our responses are not written in a way that you need a lawyer to interpret what you've received, but that's understandable to the layperson and doesn't create more questions than it answers. That's our goal. We don't always reach that goal. Some of our attorneys are more talented than others when it comes to communicating in that fashion, but it is, as a firm policy, what we strive to provide to our clients is prompt, easily understandable, efficient, and cost-effective legal advice.
Well, we get a lot of people going, I'm a client of K. Bender Rimbaum, like it's a requirement to call. It's not. Anybody can call, but you know what? Your clients love you, Robert. I mean, they really, really love what you do for them. And, I'm so glad we have you. But anyway, that's enough for me today. And Robert, we'll see you next month, first Thursday of the month. K. Bender Rimbaum. We'll see you soon, and we'll see you all next week with more Ask the Experts. Thank you so much.
Bye-bye.
Thanks for tuning in today to the Ask the Expert show on W4CY Radio and Talk4 TV. Tune in next week and every week to hear more from our experts on personal injury, insurance, air condition repairs, estate planning, Medicare, and many other topics in the areas of legal, health, financial, and home improvement. See you next week.